Okay, so you know those 79th group loan notes you've been asking about. The ones where you're not quite sure about the security backing them up. Well, we're going to dive deep into that today and really try to figure this whole thing out.
Yeah, it's definitely a situation that needs some untangling.
For sure. And we've got some pretty interesting stuff to work with here, especially these documents from Insolvency and Law.
Really helps to shed some light on what's going on.
Absolutely. So what we're going to do today is try to unpack the complexities surrounding how these loans are actually secured and what kind of protection you actually have as an investor.
That's right. We'll be looking at the mechanisms in place, the potential weaknesses, and really just trying to understand the level of risk involved.
Exactly. And to do that, we're going to focus on two key areas that are highlighted in these documents. The first is this thing called a debenture deed, which was put together by T&T trustees.
And the second is this whole situation surrounding Castle Trust and Management Services Limited, which is a bit of a head-scratcher, to say the least.
Yeah, definitely got us raising some eyebrows. So by the end of this deep dive, you should have a much clearer picture of what's going on and what it means for your investment.
Hopefully a lot less confusion and a lot more understanding.
That's the goal.
Yeah.
So let's kick things off with that debenture deed. Now, for those who aren't familiar with the term, think of it like a really formal contract that sets out all the terms of the loan and, more importantly, the security that's supposed to be backing it up.
Right. It's basically the document that's supposed to give you that reassurance that your money is protected.
Exactly. So Insolvency and Law took a deep dive into the debenture deed that was registered for 79th Luxury Living 6 Limited, and they used this company as a representative example for many of the other 79th group companies.
Yeah, they figured if they could understand this one, it would give them a pretty good idea of how the others are structured.
Makes sense. And what they found, well, it's not exactly the most reassuring news.
Let's just say there are some red flags that need to be addressed.
So the first thing that really jumps out is how incredibly vague this deed is when it comes to describing the actual properties or assets that are supposed to be securing these loans.
Right. It's like they're saying your money is safe, but they're not really telling you where it is or what it's tied to.
Exactly. It's all very broad descriptions and general terms.
And that's not just a minor inconvenience. It creates a very real legal risk.
How so?
Well, if those assets aren't clearly defined, it opens the door for all sorts of arguments down the line, especially if things go south and we're talking insolvency proceedings.
So basically someone could come in and say, hey, wait a minute. These assets were never actually intended as security for these particular loans.
Exactly. And without clear definitions in the deed, it becomes very difficult to prove otherwise.
Not good. So not only do you not know exactly what's supposed to be protecting your investment, but there's also this added layer of legal uncertainty.
And this is where things get even trickier. We've got this term that keeps popping up, floating charge.
I was wondering about that. It sounds a bit like something that could well float away.
Haha. Well, in a sense, it kind of can. A floating charge is a type of security that lets the company, in this case, the 79th Group companies, continue to use and even sell those assets in their day-to-day business.
So how does that provide any security?
The idea is that this floating charge crystallizes at a specific point, usually if the company defaults on the loan or goes into insolvency.
Okay, so it's like it suddenly becomes solid and attaches to those assets, preventing the company from doing whatever they want with them.
Right. But here's the catch for you, the loan note holder.
Yeah.
Those assets could be long gone by the time that crystallization happens.
So it's like a security blanket with holes in it.
Pretty much. It's there in theory, but the assets backing it up could vanish before you can actually benefit from that protection.
And just to add insult to injury, it seems like even if you wanted to take matters into your own hands, you can't.
Oh, you're absolutely right. This debenture deed doesn't give individual loan note holders any right to directly enforce that security.
So you're at the mercy of the security trustee, which in this case is T&T trustees.
They're the ones holding all the cards.
And what's to say they'll act in your best interest or with any sense of urgency?
Exactly. There's no guarantee. And that's a huge concern for investors.
Now, we also keep hearing about these things called covenants that are supposed to be in place to protect investors. Are they doing their job here?
Not really. Covenants are basically like promises or rules that the company agrees to follow in order to safeguard the interests of the lenders.
So things like not taking on a ridiculous amount of debt or selling off key assets without permission.
Exactly. Those are common examples. Now, in a well-drafted debenture deed, these covenants would be very specific and would really restrict the company's ability to make moves that could jeopardize the security of the loan.
But in this case,
Well, it seems like these protective clauses are either missing altogether or they're just so weak that they're practically useless.
So there's nothing stopping the 79th Group from, for example, transferring assets or offering better security to new creditors.
Which, of course, would leave the existing loan note holders in a much weaker position.
So it's like they've been given free rein to potentially undermine the very security that was supposed to be protecting your investment.
That's a pretty accurate summary.
And speaking of responsibility, what about T&T trustees? What are they actually required to do to protect the investors?
Well, that's another area where this deed is surprisingly vague.
Really? You'd think that would be spelled out pretty clearly.
You would think. But there's no clear outline of what T&T trustees are obligated to do proactively to safeguard those investments.
So are they just supposed to sit back and hope for the best?
It's not entirely clear, and to make matters worse, there's not even a legal indemnity clause to protect them if they do decide to take action on behalf of the investors.
Wait, so they could potentially be held personally liable if they try to help?
That's the concern.
Yeah.
And that lack of clarity could make them hesitant to act, even if it's in the best interest of the loan note holders.
So once again, you're left in a situation where your supposed protector might not actually be able or willing to protect you?
And it just adds another layer of risk and uncertainty to the whole equation.
So it seems like with this debenture deed, there are a lot of unanswered questions and potential pitfalls.
And when you dig into the legal language,
Yeah.
even the most fundamental question of who gets paid first if things go belly up isn't clearly answered.
You kidding? Right.
I wish I was. You'd think that would be priority number one.
Absolutely.
But the review by Insolvency Law points out that there's no specific clause guaranteeing that loan note holders have priority in case of insolvency.
So it's just a free-for-all.
It's more like a legal gray area, and that's never a good thing.
Definitely not.
Yeah.
Now, I know a lot of people might see that this debenture deed is registered at company's house and think, okay, it's official. We're good. But the source material specifically warns against that assumption. Why is that?
It's a really important point. Company's house is basically a registry. It's where companies file all sorts of information about themselves.
So registering the debenture deed there is basically just saying, hey, this document exists.
Right? It creates a public record. But it doesn't necessarily mean that the security itself is rock solid or even enforceable.
So it's not a guarantee of protection?
Not at all. It's like registering your car.
Toy.
It proves you did the paperwork, but it doesn't guarantee that the car is actually safe to drive.
Okay, I get it. So registering with company's house is just one small step.
Yeah.
It doesn't mean everything is hunky-dory.
Exactly.
So this whole debenture deed situation under T&T trustees is pretty concerning, to say the least. But the problems don't end there, do they? There's also this whole other issue with Castle Trust and Management Services Limited.
Oh, yeah. That's a whole other can of worms.
And it involves two specific companies within the 79th Group, 79th Commercial 3 Limited and 79th Luxury Living 5 Limited.
And what's particularly troubling here is that official records still show Castle Trust and Management Services Limited as the security trustee for these two companies.
Which wouldn't be a big deal except for the fact that Castle Trust and Management Services Limited is, well, essentially out of commission.
Yeah. They entered administration in Gibraltar a while back.
And for anyone who's not familiar with the term administration, is basically the first step towards a company being wound down.
It means they're in serious financial trouble, and they're under the control of administrators who are trying to figure out how to best deal with the situation.
So not exactly the kind of company you want in charge of protecting your investments.
Definitely not.
And to make matters even more confusing, the 79th Group announced a suspension of loan note payments on March 24, 2025.
Yeah, they blamed it on reputational and financial issues stemming from some police action.
Not exactly a vote of confidence.
Nope. And then just to add another layer of complexity to this whole mess, T&T trustees sent out an email to some investors.
What did it say?
Well, they claimed that they had been appointed as the new security trustee, replacing Castle Trust and Management Services Limited.
Okay, so they're stepping in to fill the void.
That's what they're saying, but the timing of this whole thing is really suspicious.
How so?
They claim their appointment was effective December 1st, 2023. But remember, Castle Trust and Management Services Limited went into administration in Gibraltar months before that.
So how can a company that's basically on its way out legally transfer such a crucial responsibility?
Exactly. It's like trying to hand off a baton in a relay race when your runner has already tripped and fallen.
Not very effective.
Not at all.
And to make things even murkier, There seems to be a real lack of transparency around this supposed handover.
Right. T&T trustees mention these legal documents, a deed of retirement, an appointment, and a deed of assignment, but guess what?
They're nowhere to be found.
You got it.
Right.
They haven't been filed with company's house, and they haven't been made available to the loan note holders.
So we're basically taking their word for it.
Pretty much. And that's not very reassuring.
No, it's not. So we've got this situation where the company that's officially listed as the security trustee is essentially defunct, and the supposed replacement appointment is shrouded in secrecy. What does this mean for the loan note holders from a legal perspective?
Well, if you connect all the dots, it creates a very dangerous situation for those who invested in these 79th Group loan notes.
How so?
Well, first of all, the enforceability of that security is now highly questionable.
Because we don't even know who's actually in charge of enforcing it.
Exactly.
Yeah.
It's a legal mess. And then there's the issue of individual investors not having the power to take direct action.
So you're completely reliant on the security trustee, whoever that may be.
And right now we have a situation where the officially listed trustee is likely unable to act, and the replacement status is unconfirmed.
So basically you're stuck in limbo.
And that limbo could mean losing your investment. It's not a good place to be.
Definitely not.
Yeah.
So for anyone listening who's invested in these 79th Group loan notes, what should they be doing right now?
Well, according to the source material, time is of the essence. Taking action sooner rather than later is absolutely crucial.
So don't wait around hoping things will magically sort themselves out.
Right. And luckily, Insolvency and Law, the folks who did all this digging, are actively helping investors navigate this mess.
That's good to hear. What are they doing specifically?
Well, for starters, they're carefully reviewing the existing security documentation to really understand where the weaknesses are and what legal challenges might arise.
So they're doing their homework.
Oh, yeah. And they're also guiding investors on how to form a lender's majority group.
What's that?
It's basically a way for investors to band together and have a much stronger collective voice.
So there's power in numbers.
Absolutely. And that can be really helpful when it comes to negotiating with the 79th Group or pursuing legal action.
Makes sense. And I understand they're also offering legal representation in potential collective enforcement efforts.
That's right. So if investors decide to take legal action, they can have experienced lawyers fighting for their rights.
That's reassuring. So for anyone who wants to explore these options and get in touch with Insolvency and Law, what should they do?
The easiest way is to send them an email. Their address is investigations@insolvencyandlaw.co.uk.
And I believe they also welcome inquiries from anyone who's owed money by a company, not just those involved with the 79th Group.
Right. So if you're in a similar situation, don't hesitate to reach out.
So to recap, we've uncovered some pretty serious issues with the security arrangements for these 79th Group loan notes.
The debenture deed under T&T trustees is riddled with problems, and the whole Castle Trust and Management Services Limited situation just adds another layer of complexity and uncertainty.
All of which means that those who invested in these loan notes are facing a very real risk of losing their money.
It's a stark reminder that even when investments appear to be secure, you need to really dig into the details and understand the fine print.
Yeah, absolutely. Don't just take someone's word for it. Do your own research and make sure you're comfortable with the level of risk involved.
And if you're not comfortable or if you have any doubts, don't be afraid to walk away.
It's your money and your future. Protect it.
Couldn't have said it better myself.